Thank you all for coming today. We really appreciate your attendance here today for the IP session. My name is Chris Scherer. I'm a partner at DeWitt in the Intellectual Property Group. I'm also a member of the Executive Committee. And Joe, you can introduce yourself.
Good afternoon, all. Again, thanks for joining us. My name is Joe Miotke, also a partner at DeWitt. I'm co-chair of our Intellectual Property Practice Group and also a licensed patent attorney, as is Chris.
Yes, and today we're doing not another AI presentation using IP fundamentals to create value and mitigate risk in manufacturing. So not another AI presentation. Not that there's anything wrong with AI presentations, but we just wanted to catch everyone's attention. Joe and I have actually done a number of AI presentations this year, so we have nothing against them. We're just working on this. Got it, Joe? Okay, so we're going to do a little workshopping today. Hopefully you guys are in for thinking about some IP fundamentals and putting some pen to paper and trying to just join along in this, because sometimes this material can be a little bit dry. So we are going to introduce a product. In this case, it's the Beerbrella. You have a patent in your hands for the Beerbrella, which is quite interesting. And we are going to go through all the different types of intellectual property, explain them to you, maybe workshop a little in view of the Beerbrella, and then give you some takeaways for each type of intellectual property we talk about, and then recap with some questions. Okay? Did we lose our clicker? So here it is. The Beerbrella, which includes this bottle of beer or some sort of beverage container, a clip or cuff, and a vertical umbrella pole and an umbrella at the top. This is the Beerbrella. This patent was filed several years ago, and I know we're in a room of manufacturers, and I hope that this doesn't clear the room, but this patent's expired, so if you want to run out of here and go manufacture this, have at it, okay? So we're all set.
And then just a little background on this patent. It was actually, the patent itself was written by patent attorneys for use as a tutorial. So it wasn't a project, it wasn't a product anyone specifically expected to commercialize. The attorneys filed the patent and let it go abandoned right away to use it in tutorials just like this.
Yeah, and I did find also that someone not involved with the patent filed for a trademark application, had it allowed, and then never followed through with it. So someone must have found this along the way or sat in on a tutorial such as this and thought about going forward with it. So just an interesting tidbit before we get going. Okay.
So then kind of kicking off, as we worked through this, as Chris already mentioned, with each different category of intellectual property, we'll kind of, at least for the first 2 or 3, we'll step back and just do some workshop exercises to talk about, in the manufacturing context, and more specifically using the Beerbrella as our example, some exercises in how you would protect the Beerbrella product with the specific category of IP that we are talking about. So starting out then with even just level setting with what we mean by intellectual property generally, and even before there, we start with the free market rule in the United States that technology can be freely copied unless it's specifically protected by law. So of course, it's that specifically protected by law part that gets very important. And frankly, the protected technology and other intangible assets are what we mean when we say intellectual property. So really, intellectual property generally is the vehicle through which you're going to extract value in your intangible assets from your company.
And just we're going to go through a lot of material here quickly. You can tell we got a good pace going here. If you need some clarification, raise your hand. We have a small group, so we can stop it and talk about it a little bit. But the important point to that slide is your captured technology, protected technology is your IP. If you don't do that, it's public domain, right? If you miss something, it's out in the public domain. So that was a takeaway from that slide.
And then even kind of wrapping up on the introduction in that, something very interesting is Several groups have done studies that when we looked back to 1970, when the United States was exiting essentially its first manufacturing-based economy, when they looked at the market cap of the S&P 500, they found that approximately 80% of the value of the market cap of the S&P 500 was in tangible assets, and only 20% was in intangible assets, the primary driver of that value being intellectual property. And then you fast forward 50 years plus to present day, and we've essentially seen an economic inversion where now when they take a look at the S&P 500, we're seeing that over 80% of the value is tied up in intangible assets such as intellectual property, and only 20% of the value generally resides in tangible assets. So the takeaway here is that intellectual property is a very, very important component of businesses, or important component of the value of businesses. And when we look at manufacturing, and probably even more specifically contract manufacturing, in our experience, sometimes intellectual property is a bit overlooked. So that's where we just want to talk about this and hopefully plant the seed so that as you go back and look at your businesses, start thinking about ways you can find value in your company, that it's been there the whole time, and find ways to extract the value from it. Oh, go ahead. Well, and then maybe just the last part of that is specifically when you're getting ready to exit, when you're getting ready to sell your company, create an ESOP or various other exit strategies, when you're looking to place the valuation, intellectual property can be a very significant component of that, but you don't want to wait until, you're 6 months out from closing to try and put all this together. Intellectual property takes a lot of forethought, a lot of planning to really set up and create that value.
Great ESOP mention, given our managing partners in the room and our number one ESOP attorney, Tim Stewart. Great job, Joe. The other thing I wanted to mention too that should be mentioned is that one of my manufacturing clients actually hires me on a contract basis to be in-house counsel, in-house IP attorney, and I do that on a bi-weekly basis. And Joe and I have developed this for them, this whole process that we're going to talk about. We've done from me being in-house and Joe outside and working together to come up with these plans for manufacturing companies.
So in-house counsel, out-house counsel.
Yeah, outhouse counsel. Yep. That's Joe's title, outhouse counsel.
All right.
So good. So here's the 4 general categories of IP. They have different characteristics, so we have to go through all of them and make sure you understand what they are and how they work and how they operate. So do you want to go through the slide, Joe?
A real quick preview now, and we'll circle back and go through each of the 4 in more detail. The first 2, patents and trade secrets, the first 2 primary categories of intellectual property. I view patents and trade secrets as essentially opposite sides of the same coin, because they're both focused on protecting core technology or core innovation in your products. So these are the 2 vehicles that really focus in on the technology. From there, we go to trademarks, which are much more focused on branding. For purposes of our workshops, we're actually going to start off with trademarks in an exercise, but typically patents and trade secrets are primary value drivers within a company. And then we wrap up with copyright protection, and copyright protection can certainly be a very important component of your IP portfolio in certain businesses. In our experience in the manufacturing context, it's almost more about risk mitigation, or just knowing what not to do so you're not infringing other people's copyrights. Yes, Tim.
Patents and trade secrets are they mutually exclusive? Meaning, if something is a trade secret, that means it's not patentable, and vice versa, or is that?
So
it might still be patentable, Tim, but you might choose to keep it a trade secret, is the way that I would explain it to clients, right?
Why would you choose not to patent it? Just because you're afraid of it getting out there?
Right, exactly. Joe's gonna talk about this more, but one of the ways I think about it, there's many ways to think about patents versus trade secrets, but one of the ways is if you were able to keep it a secret, it's not easily reverse engineerable, or it has a very long shelf life or a very short shelf life, you may want to keep it as a trade secret. It's not worth patenting. Or it's not worth patenting if it has a very short shelf life. And if it has a very long shelf life, you want to keep that secret. When you get a patent, you're telling the public how to operate, how to use this thing or make this thing or whatever your invention is, right? And then you have a monopoly for 20 years. After that, it's free game, right? Like the beerbrella, right? Free game.
And just adding more color to that, trade secrets are typically very important in the chemical space where the runway to commercialize can be longer than the life of the patent. So for that reason, you want to hold it back as a trade secret because otherwise your patent will have already expired before you're even starting to commercialize and your competitors can freely copy it.
It is a good thing to describe by example, right? Formulas, Coca-Cola, right? Number one, that's a trade secret that's not patented because everyone would know it already and be making Coca-Cola, right? Some like financial algorithms and software, things like that would be something that,
By shelf life. Coca-Cola's got a long shelf
so
life.
long shelf life.
Been around a long time.
You don't want that in a patent. So next slide, we'll start with trademarks. And typically, right, if we were speaking to a big technology companies or someone more focused on inventions and trade secrets and maybe not a room full of manufacturers, we might start with patent and trade secrets. But Joe and I do a lot of work with our business practice group. We advise the business practice group lawyers in DeWitt on how to navigate this with their clients. We show them what issues they need to look for with their clients in the intellectual property space. And I always find myself telling the business practice group lawyers, hey, your clients may or may not have patents. They may have no patents. They may have some trade secrets. They may have some copyright issues that they have to deal with. But all of your clients have trademark issues, for sure, right? They all have a company name at the very least that's a trademark issue, right? They all provide services or products or something that, or subsidiaries, right? That require us to think about their trademarks and whether they're all tied up and figured out. So trademarks are, we'll just read it, protects words and or symbols used to identify the source of goods and services and to prevent consumer confusion. So simply stated, it's a source identifier of your goods or services. That's what a trademark is, okay? And so a trademark can be a word or a combination of words. It can be a collection of letters, right? BASF is a company, or that has, I think those are random letters, right? BASF, and that can be combined with a symbol or a logo on its own. We all know this is the thing where you drive down the street and you get to the end of Blue Mountain and you've seen 8 trademarks, right, on the sides of buildings. Okay, and one thing we advise our clients on is to avoid, if you're coming up with new trademarks for a product line or a service line that you're providing, to avoid descriptive or generic trademarks, right? This is kind of something that we oftentimes deal with marketing teams that don't quite understand trademarks well, is that they want to try to trademark descriptive marks. And when you file for a descriptive trademark application in the US Patent and Trademark Office, you will likely get a rejection. Now, the difference between descriptive trademarks and generic trademarks is that descriptive trademarks, through long-term use, can enjoy a federal registration eventually if you show that that mark has acquired secondary meaning and it has grown to a point where people identify it as a source of goods and services. Generic marks, on the other hand, such as car for an auto dealership or aspirin, right? Okay, those aren't registrable ever. In fact, what ends up happening oftentimes is companies will come up with a really great trademark that does such a great job that people start adopting it as the actual name of the product, right? And then they have to fight off becoming generic. The best example of this is Kleenex, right? And Thermos Xerox, right? All of those types of brands. But Kleenex, if you go in a grocery store now and actually look at the Kleenex box, it will say Kleenex brand tissue, right? Because they're trying to get people to understand that Kleenex is their trademark and this is actually, they're selling tissues, not Kleenex, right? Okay? So, which actually, strangely enough, they must have used this on a tutorial, because typically if you look at your patent that we handed out, the title of this patent is beerbrella, okay? We would, as a group, never do this. We would never use a company's trademark as the title of a patent application, okay? That is putting yourself on the road to genericness, okay? So I think when they did this as a tutorial, I'm sure they probably touched on this. We would call this shade device for a beverage container. That would be the name of the patent application.
And one of the ironies I add here,
Yeah.
I kind of, just like I explained to clients, like if you've got antitrust problems, in some ways that's the best problem to have because it means you've already won. Because if you've got that much market share and you're printing money, I shouldn't say it too loud, but pretty good problem to have. Along those lines, like if you're worried about your trademark becoming generic, again, a wonderful problem
Yes,
to have
exactly,
because
exactly.
you've probably got such market share with your product. But again, I say that somewhat flippantly because that means you have a really valuable trademark that you really have to take steps at policing and branding it properly.
And to Joe's point, you can deal with that problem. Okay, it's a great problem to have, and we can figure out how to help you with that problem, right? Kleenex brand tissue, or taking other steps to make sure your marks don't become generic. All right. So the types of things that you would try to trademark in your manufacturing business is certainly your house mark, whatever the name of your company is, right? Any subsidiary names, any product lines, individual products. Also, I left off of here for some reason, any services, service offerings that you have at your company are trademarked sometimes, right? And so what I do with my clients is I sit down with them and say, what do you think you're using as a trademark? I look at their website, look at their literature, and say, and their house mark, and how they're using their house mark on their website and other literature, and say, let's build a hierarchy, okay? Let's put all your marks in an order of most valuable to you to least valuable, okay? And we would build this pyramid of trademarks that they're using or going to use soon into a hierarchy. And then basically, the exercise is really a big cost-benefit analysis. You take your hierarchy, you say, what is your trademark budget, okay? And you start executing on it. File for the top 1 or 2, 1 year, however much budget you have, and work with the client to start protecting their trademark portfolio. And then whatever can't be registered right away, make sure they're using a TM with those unregistered marks so they start building common law rights in their trademark portfolio without US Trademark Office registration. So that's really, in a really simple nutshell, the process that we go through to identify trademarks for the client and to build their portfolio and manage their portfolio for them.
And then one thing to add too is that when companies are on the front end of developing a product, and I think we may touch on this in the next slide as well, is doing what we call trademark clearance searches. So as you're starting to develop new brand names, new trade names for your products and services, to early in the process do trademark clearance searches just to make sure nobody's using that mark already, because
or have it registered.
Or has it registered. Because if you don't do that, you put all this time, effort, and sometimes a lot of money into building the brand only to realize rats. Someone's already out there with it. One client described that to me. It's kind of like hitting a parked car. So just to get ahead of it and search it. But as I say that, some clients really hate doing that with us because for whatever reason, certain brand names just kind of come in style. Like all of a sudden, a certain brand or a certain niche market, one of them I've just recently experienced, I'll say odor reduction, believe it or not, and trying to come up with trade names in that space. And it was just wild how everybody, I think, what is the phrase? They say odor is the new stain along those lines. So, trying to find marks that weren't in use already was really difficult. But again, very worthwhile to do the exercise. So we found something we actually could register and start building around.
Good point to bring up searching, Joe. We didn't consider that before. And it's even more important. Searching becomes more and more important the bigger your portfolio is, really, from a geographic standpoint. So if you have a global business and you want to use those trademarks in a number of jurisdictions across the globe, it becomes exponentially important to do some searching, because in the US, you might be able to use Beerbrella, but someone might have registered it in Europe already, right? Or in Australia or somewhere else. Intellectual property is jurisdictional. So if you have a global business and you have a trademark that you really want to use, we should do a little searching for you. And we can do that in a number of different ways. Our domestic searching, I would say, typically we can do that within our office walls with our associates. I'm about to do a search for a client in the US and Europe, and we'll use third-party search tools because they're just more efficient sometimes and do a better job. And so we'll search global jurisdictions using that and then analyze the results for the client and say, here's what we have, here's our concerns, and so on and so forth. So very good point, Joe. Okay, next one. We'll go a little faster here because we need to get to the workshopping. So what does a trademark do for you? We kind of already covered all of this, but let's just still go through this real quick. So when you have a registration, a US trademark registration, you can use the R circle that's shown up here in the image, right? And what does this do for you? It allows you to exclude others from using a confusingly similar mark, okay? So does that mean, Tom, what company do you work for? Zimmerman. Okay, Zimmerman is financial services? Architectural, okay. So there are many, maybe this isn't a great example because that's probably a surname, but I'm going to go with it anyway, right? So Zimmerman for architectural services, but if I decided to file a trademark application for Zimmerman Hamburger Shop and opened up down the street, I'd probably be okay. You wouldn't be able to stop me from using that or from registering that. So confusingly similar takes into account not only what the mark looks like, but what it sounds like, what goods it's being used with, what international classes it's registered in, channels of trade. I'm trying to get all the DuPont factors, but I'm not going to get them all. There's like 10 or 12 of them, but those are that you get the idea, right? That people can have identical marks as long as they're not confusingly similar. They can even have really similar marks too. And then rights exist for duration of use in commerce. So in the US specifically, the hallmark of trademark law is really use. So you have common law rights as long as you're using the mark in commerce, and you can get a US federal trademark registration as long as you're using it and you renew it every 10 years. Okay, so those are the rules there. And then we also put in the right to be left alone. This refers to the situation where you have a US federal trademark registration. If you've been using it continuously for at least 5 years, you can file what's called an incontestability declaration and say, I've been using this in interstate commerce. I've been using Zimmerman for the past 5 years in interstate commerce, and it's called a Section 15 declaration. And then your mark is incontestable even to prior users that don't have a registration. So it's kind of an extra little kind of galvanizing of your trademark, I guess, so to speak.
You're just not worried about people coming out of the woodwork 10 years out saying, hey, that's, you're using my brand. Mm-hmm. Not anymore. So.
Nope, too late. Okay, so I think we can go to the next one, Joe. Okay, so here is the workshop part of this presentation. So we don't want to ask you to do any kind of design marks right now, but maybe some of you can write down some names for this, some trademarks that you think would be kind of fun or effective, not descriptive, not generic, of the goods and services, which would be beverage shades, I don't know, beverage, things that keep your beverages cool, right? I don't really understand this because if someone hands me a beer, I don't really need something to keep it cool.
We don't it's long gone before it's going to get cold. But not sure if sunlight is bad for White Claw or not. But yeah.
So any ideas? We don't have 50 people in here, so we could just anyone want to raise their hand and give us a trademark that they think would work well with this, or I don't know, describe a symbol even or a logo. No takers? Beer Brella is not bad.
I got beer gone.
Beer gone? Okay, that's okay. Okay, good.
Well, that's a capital G.
Okay, but all right, that's good.
I've got beer happy. Don't let beer comes out that keeps you dry.
That's good. That's like a tagline too, which are trademarkable as well. You can get a trademark on a tagline. They're actually easier to register because you're less likely to find one that's it's exactly like yours. So that's good.
Yeah, not to overshare, but one of my more
Oh, no,
favorite.
here we go.
No.
When Joe
But
says
a
not to
really fun
overshare,
hobby is
we're in
when
trouble.
You go back, when you look at some of the beer slogans from like probably the late 1950s forward, and some of the brilliant slogans they had. My favorite is still among them would be Schaefer beer, the one beer to have when you're going to have more than one. But anyway, but I say so, Cameron. Like to yours, that's awesome when you bake in the humor. But yeah.
And the thing I was thinking too, any golfers in here? Yeah? What do you think when you see the umbrella, like a multicolored umbrella? Yeah, exactly, right? You could do something like that, and it wouldn't be confusingly similar probably because the Palmer trademark has to do mostly with golf things, I would think, right? So anyway, we just wanted to do a little workshopping here, so thank you. I don't think any of those were really, certainly not generic. I would anticipate a descriptiveness rejection maybe from an examiner if you use the term beer in it, maybe. But I did look up, there was another party, not the fellas that filed for this patent, but someone else subsequently filed for the trademark application. And they got it allowed, so the examiner didn't think it was descriptive, which is good, but then they didn't act on it and it just expired. So I think all of those are very good, not descriptive and certainly not generic. So
Brew instead of beer, do you think that help the
probably, yeah, I think so, because it's less specific. It could be other brews. Yeah, sure. Okay. I think we might go 2 slides, Joe. Yeah, draw your trademark on that page. Okay, so just the takeaways again, real quick. I think we're still doing well on time here. So identify and create your trademark. So like we said before, that kind of step before creating your hierarchy is really taking a look at what you're doing with your business and identifying the trademarks that are already there, identifying the trademarks that you need, and creating those and bringing them to your trademark attorney. Build your hierarchy with your trademark attorney, figure out what are the most important marks, register the most important ones that your budget allows, and then using a TM with your unregistered marks. So you're putting others on notice that you're using this as a trademark and building your common law rights in those trademarks, okay?
And then I think part of this too, another takeaway and part of like building your hierarchy and your process is working with your law firms to make sure you've got a good database of your trademarks. And this is something your law firms will typically do for you if you're working with them. Yeah. But a very good docketing system so that you don't miss renewal dates and have trademarks go abandoned, because that can be a real headache.
Yeah, we could talk all day about the nuts and bolts of actual trademark prosecution and how that works, and how we work with clients to file them and argue with examiners and get the required specimens and dates of first use and all of those things. But it does take good paralegals, good data acquisition and organization skills, and to just make sure we have a docketing system that we use for the clients that keeps everything on track for renewal. Yeah.
And then for valuable trademarks, just knowing there are other companies out there just waiting for certain marks to go abandoned so they can refile. And I've actually worked on clients with that, where we had an eye on relaunching a brand, and the very day that the mark went abandoned, we didn't the original company didn't file their renewal. We filed a new application on it and sort of snuck it out from under them, so to speak. Yes. Right. Well, like I say, we were doing it like, you can, in the trademark filings, you will see the final day that the maintenance, you've got like a 1-year window to make your maintenance fee payment and then a 6-month grace period.
Yeah.
And so at the end of that 6-month grace period, someone else can file for it. A thing to keep in mind with this is that if the original owner of the trademark, if they're still using that trademark in commerce and somebody else tries doing this, it's a headache, but you can probably still try and, prevail in like canceling, well, I guess it would be opposing the new registration, but it's a real pain in the neck. But it's more so in your trademark portfolio where, a brand gets abandoned for a while, you stop using it, but when you're looking at the portfolio, sometimes you just want to relaunch it even for nominal use if you're going to bring it out in a new.
No, and I was just going to cover once you have a registration, you have to make a filing of use between the 5th and 6th anniversary of that registration, just to show the trademark office you're still using that trademark in interstate commerce. So then your mark continues on in the register. And then after that, they're 10-year renewal periods, 10-year from the registration. So you have that one in between the 5th and 6th anniversary, then you have one before 10, 20, 30, 40, 50, as long as you're using it still.
And kind of a cool example of this, and something I actually wasn't involved with, is the pain reliever pill Nuprin. If anyone remembers Nuprin, it used to be, one of the big pharma companies, probably through the 80s, even into the early 90s, owned it as a name brand for a pain reliever, and they actually took their eye off the ball, and I don't think they were using it very effectively either. They may have stopped selling it, but then another company came in, swooped up, filed for Nuprin, and actually launched it as a white label brand, and they sold it for a fortune to CVS. So now Nuprin is a CVS kind of white label brand, and so that's sort of a place where abandoned trademarks are getting more and more popular.
And fashion too. You're seeing a lot of, you're seeing a market now for old fashioned brands that were abandoned many years ago that folks are refiling and restarting again.
So if you see content with PTO, brand taking, and it's abandoned in the system, does that mean it's truly been abandoned?
Right. It means they haven't continued to renew that trademark registration in the trademark office. But to Joe's point, they still may be using it somewhere and still have common law rights in the mark somewhere. Let's take a look what's going on. Then we need to drill down a little bit more, because common law trademark issues get really, really tricky. Yeah. It depends. Use for a good that you're selling means a little bit more than a use for a service that you're showing that you offer over a website, right? That's okay. It's typically easier to show use for registration purposes for a service rather than a good. If that makes sense. Yeah. Okay. Kinda. Okay. All right. Next one, Joe?
Yeah, so any other questions before we finish up trademarks and move on to patents and trade secrets?
All right, good.
Hearing none, we'll move forward here. And realizing that it's about 20 minutes until open bar and hors d'oeuvres, and certainly we don't want to stand in the way of that, so we'll kind of keep this moving along.
Yeah, we're a little behind. Yep.
But certainly if you've got questions, by all means, please ask them. So very happy to answer questions, but we'll also treat some of this a little bit more quickly. So moving on, as I mentioned at the introduction, kind of now talking about patents and trade secrets, again, kind of opposite sides of the same coin in that both are used to protect core technology in your products or services. Starting out with patents, interestingly, patents are actually a constitutional right. You have the patent clause in the Constitution that serves as the foundation for our whole patent system in the U.S., so very important. But even the founding generation of the U.S. recognized that there's this real tension between monopolistic activity towards technology versus free use. But if you don't strike the proper balance, you're going to stifle innovation. So the whole point of the patent system is to incentivize innovation without stifling competition. And I use the monopoly word where antitrust lawyers would start hissing because just because you have a patent doesn't mean you have monopoly. But I won't nerd out any further on that because it's already turning into white noise and we're already short on time. So this is not helpful. But basically with patents, it's in essence, a patent is that in exchange for filing your patent application, which through which you're going to tell the world how to practice, make, and use your invention. In exchange for that public disclosure, the government, as long as you meet certain criteria, essentially that it's a new and non-obvious improvement over existing technologies, the government is going to give you exclusivity for a set duration of time. Currently, 20 years from the earliest priority date, typically the date of filing. So it's this bargain struck through your constitutional right to a patent, is that in exchange for the public disclosure, you're going to get exclusive rights in that technology. Patent protection is by and large the most powerful form of IP protection available in the United States. So it should come as no surprise, it's also the most expensive to obtain. So patent applications and certain technologies can get very expensive, but again, because they're worth it. But when you step back within your company, the starting point really is taking a look at the innovation going on within your company and setting a budget each year, typically, like this is the budget we're going to use to file patent applications with, and start aligning the strategy with your budget. But keeping in mind, and we'll move on to the next slide.
Yeah, and unfortunately, we don't get these beautiful red ribbon gold seal patents anymore. They did away with those, and they changed the design of the physical patent, and now they did away with physical patents altogether. So now all you get is an electronic patent. Although from time to time, I don't know, they're trying to phase it out. We'll still get a paper patent printed once in a while from the patent office. But these do not exist anymore. It's old graphic, but it looks nice, so we left it on there.
Yeah, we still like our ribbon copies. We're old school.
We do.
But within your organizations, taking a look at the innovation and starting to think strategically about what are some of the core technologies we've developed that A, drive revenue, and B, our competitors would potentially want to copy, because those are probably the two big reasons you should seriously consider filing for a patent application. There are others as well. In the manufacturing setting, those are typically the two big drivers. A big thing to keep in mind is that in the United States, you only have a 1-year grace period after any sale or public disclosure of the technology covered by your patent application, the date by which you have to file. So you've got to act relatively quickly. And frankly, to keep in mind that throughout most of the rest of the world, there is no 1-year grace period. So you want to have a good process in place where you are making the decision, do we file a patent application to protect this technology or not, before there's any public disclosure or sale of the technology.
Yeah.
Go ahead, Chris.
No, yeah. So, and I think that's something that our team is particularly strong at, is our foreign patent filing and strategy. And it is very important. I can't even stress it enough that if you have any kind of foreign market where you feel you need intellectual property protection, specifically patent protection, that you talk to your IP attorney first before you show it to anybody. Before you obviously offer it for sale, before you get into joint development agreements, you need to see us or your IP attorney to make sure that you have everything buttoned up before you go to sell or go to show somebody, because you could really be throwing your Canadian, Mexican, European rights out the window. Okay, and we call this patent harvesting with our big technology clients. We didn't want to scare anybody in manufacturing who may have only a few patents, so we called it, what do we call it? Innovation review? Yeah. Innovation review, right? Patent harvesting is a big word, big scary thing.
Yeah.
Yeah.
There we go.
There. Periodic innovation review, patent harvesting. Good.
So then other points to keep in mind with patents are that there is no such thing as like a global patent or a world patent. In other words, patent protection is country specific. So a lot of times companies will start in their home country, and then there are vehicles to make it more efficient to seek patent protection in foreign countries. But just keeping in mind country specific, and also just knowing that it can get real expensive real fast to start trying to protect your technology in lots of countries. So that's
and on my last point, there are vehicles, as Joe pointed out, to still preserve your foreign rights while only making a U.S. filing. But you just can't disclose before that priority U.S. filing, or you could jeopardize your foreign rights. So in other words, if we file a patent application here today, and we did not disclose this invention before offered for sale in the U.S., we filed it in the U.S. today, the Paris Convention gives us 1 year to file in any other jurisdiction around the world, and your rights will be preserved through your U.S. filing. You will get that filing date. Okay, so if you file it in the U.S. and then you start selling it in the U.S., you will still be able to file in Europe if you file in Europe before that year is over, that Paris Convention filing date. And then also, if you, this is probably more than we wanted to get into, but I figured let's rock and roll. If you file here and in a year you're like, I don't know if if Canada's a market or Europe's a market or where this has potential, there are other vehicles. One's called the Patent Cooperation Treaty, or PCT. You can file a PCT application within a year, and that kind of captures most of the globe, except notably Taiwan, Argentina, and a couple other countries you probably never heard of before. So there are vehicles to preserve your foreign rights if you want to file in the US first. You just can't make that disclosure of your invention before your filing date.
And then, kind of starting to bring it home with patents is also keeping in mind that companies will use their patent portfolios both like offensively and defensively. So by offensively, I mean keeping competitors away from copying your technology. That's one of the more common primary common uses of patents. But also many companies will build up a robust patent portfolio and intentionally start, well, we'll get into in a little bit, writing the patents to cover their competitors' products, just so that in the event that you launch a product that unknowingly might infringe company B, one of company B's patents, and company B fires off a cease and desist letter to you saying, stop copying us. It's always wonderful when you go into your patent arsenal and find one of the patents you've written to cover one of company B's products. So you get the cease and desist letter, saying F you, and you get to, read it and say, F me, no F you back. And then, but basically, part of this, and not to use so much military parlance in it, but you build up your patent arsenal to create mutually assured destruction in the marketplace. So that for this reason, it's why you don't see Apple suing Microsoft for patent infringement, because you realize that's not the best manufacturing example. You don't see GM suing Ford for patent infringement, because GM would fire off a letter saying, hey, Ford, you're infringing 5 of our patents, and Ford would fire right back saying, you're infringing 15 of ours. So just keeping that in mind. Yeah. So keep her moving too, right?
Yeah, let's do it.
Yep. Okay. So, very briefly, part of the handouts here is we just gave you the actual patent for the Beerbrella. Won't go over it in too much detail, although how many people in this room have seen a patent before? Okay, so about half and half, but just basically, at your leisure, you can kind of nose through this as just an example of a pretty basic patent. Typically, it'll start out, the cover sheet, which provides, the summary information for the patent, who the inventors are, who the assignee or the owner of the patent is, the date it was filed, and other information. From there, you then get the drawings, which are, figures or drawings showing what the invention is with reference numbers. And then you get into the detailed description of the technology, and that's where you describe how to make and use the technology, and you'll see that the description is with reference back to the reference numbers. You're sort of thinking of the first part of this written description is kind of the operator's manual for how to practice the invention. And the real key to the patent is the very last part, which are called the patent claims. Easy to identify because they start with something along the lines of we claim :
So that's back sheet column 4. That's what Joe's talking about now.
And then just with the patent claims, when I take a step back, there's actually a separate bar exam that the patent attorneys in the room have to take to become registered to practice before the patent office in order to represent clients filing patent applications and hopefully eventually get them issued. And in becoming a licensed patent attorney, the way I describe it is we more or less learn to speak a foreign language. And we use this foreign language to write these patent claims. So, when you first start reading these claims, it can only be one sentence, and it's an extraordinarily specific, structured way of writing. So, kind of a caution that if you're going to if you're going to try and read and interpret patent claims yourself, be real careful because it's very difficult to do.
Yeah, and another note: if you haven't been through the patent process, all patent attorneys are scientists. Joe and I are both engineers by education. Many of our partners have PhDs in life sciences, and so we all are educated in science so that we can understand the really smart people coming up with the inventions, or at least be taught, right?
I've heard that. Yeah. So we speak geek.
Yeah, so we have a question in the back. Go ahead.
Just out of curiosity, how different are patents? So year one or whatever, what would have to change to say that sales creative, that's somewhat relevant now. It's a foot tall, not 6 inches tall. Is it like percentage of the document, percentage of it has to be different?
So we'll take you through that real quick, right? So claim one, you see claim one on the back. So if you had an infringing product, and Joe's going to take this answer away from me in a minute because he's the litigator. I'm the guy who mostly writes the patents and manages portfolios. Joe's on the other end, right? So basically, an infringing product, if you look at claim one, would have to include every element in that claim to infringe that claim. And in this case, infringe this patent because that is the only independent claim in the patent. Do you want to talk about claim construction at all?
Well, I think maybe the real short answer to your question is the very infamous lawyer answer that it depends. But I mean, it'll largely turn on like what technology space you're in. In certain technology spaces, very small changes can make a big difference. And as a result of that, a small change might enable you to get a patent issued over one that already exists. I mean, I think you think of it in terms of, what's the nature of the change that you're making to the technology? And actually, a point to make here, though, to be really careful about, and I thank my colleague Aaron for reminding me to bring this up earlier today, and perhaps almost forgot. But one thing to keep in mind is just because you get a patent protecting your product, that doesn't automatically mean you can sell the product out in the marketplace. An issued patent only means that you can prevent other people from practicing that technology. Because a lot of times when you obtain a patent, you're improving somebody else's technology. So if the underlying technology that you improved also has a patent on it, you probably aren't able to sell your product unless you get permission, or what we call a license, from the underlying patent owner as well. So again, it can get complicated, but just something to keep in mind. So I've had a lot of kind of one of those urban legends out there. Yay, I've got a patent I can sell. And that's exactly wrong. So just to keep moving here, because I can see the clock is ticking. So we'll skip ahead to
the trade secret.
Yeah, basically with trade secrets, as I say, opposite side of the same coin with patents. When you're thinking about trade secret protection, and kind of to Tim's question early on that really covered this, is that at the front end of your kind of your patent harvesting or your technology review, when you're looking at technologies, you want to ask yourself, can this technology be reverse engineered when our competitors buy the product? So if your competitors can buy your product or get their hands on your get their hands on your product through legal and appropriate means, whatever, they're free to try and reverse engineering everything in that. In fact, they're encouraged to do so. So any of the features that can be reverse engineered, you should seriously consider filing for patent protection, because that's the only way you can prevent the competitor from copying that feature. So in other words, we go back, if that feature they want to copy was one that was very innovative and you filed a patent on it, you can still stop them from copying the feature. But if you don't file for patent protection on it and the competitor can figure out how to do it, they're free to do so. But for certain aspects of the technology, and as I mentioned earlier, A lot of times this is in the chemical arts, and in the manufacturing space, this is on a lot of your manufacturing techniques or just your internal processes for how you're making the project, improving your efficiency, improving the properties of the product. If those are things that can't be readily ascertained, you want to think about, all right, let's not file for a patent on this. We're going to hold this back as a trade secret. The key to trade secret protection is that you've got to take reasonable efforts to maintain the confidentiality of that specific piece of information. Two primary ways you do that are non-disclosure agreements and your employment agreements and employee handbooks that expressly include an obligation of confidentiality on your employees.
Yeah, one other thing I want to add that I thought of too, off Tim's question, which is really good, is that if you're not sure about an innovation that could be a patent or a trade secret, one other strategy is I've actually never used this, but I know it exists if we ever had this dilemma, is to actually file a patent application, okay? And in the US Patent Office, you can request non-publication of your patent application, okay? So when you file it, you can say, I don't want this published in 18 months. I want it to be kept secret in the patent office, okay? And if you have a hard time, and you can only do that if you don't have foreign filing that's going to result from this. That's part of the rules. If you have foreign markets where you want to file a patent application, you have to let the application publish, okay? But if you don't, if it's a US only type of invention, you can file in the US Patent Office, request non-publication. If you can't get the application by the examiner and into a patent, to get a patent issued, then you can just walk away from it and it's still confidential and you can keep it as a trade secret. So that is one strategy, Tim, if you have kind of this, I'm not sure, is this a 20-year deal or is this a long-term kind of technology and is it patentable anyway and that sort of thing. But definitely what Joe said, manufacturing optimization plans, solutions, recipes, those are all things that you want to think about in trade secrets.
Before we wrap up, briefly touching on copyright, any questions on patents or trade secrets? Otherwise, happy to discuss these over cocktails too.
Yeah.
So, yes, they do steal everything. Although we just get that. That's
everything.
That's an overgeneralization, but with the forced technology transfer, oh yeah. But I would say that, interestingly, though, the Chinese patent system has gotten continually stronger, actually.
Yeah, I think that's true.
And actually, though, I guess being careful in how I choose my words, but even in more recent times, the Chinese patent system has gotten so strong, it can really have adverse effects on US companies in China now. Yeah. So it's kind of been set up. So even, yet another reason US companies are trying to get out in some segments as fast as they can. But an interesting part too with the enforcement of patents in China is now the whole social credit score is implemented in the patent system. So if the Chinese government issues an injunction against a Chinese company, if the owners of that company continue to violate the order, the Chinese government will actually lower their social credit scores, such that they can't travel anymore. So China actually has, yes.
Yeah.
It's a mess.
The rule used to be don't bother filing in China. But in the last, 15 years, they created their patent courts in the last 15 years. And they've become better at enforcement and a lot of things. They've integrated rules and design patents with the rest of the world. But as Joe pointed out, for whatever reason, I think from the business side, clients are now filing less and less than they ever have in China. But I think 5 years ago to 15 years ago, we had a lot more action in China, a lot more people wanting to file there because the courts were becoming better and the environment was better, right? But now I see it going down the other way. And in fact, I was just at IPO conference last week in Chicago, met with a couple Chinese associates, and they did confirm their filings are down in the China IP patent office for the first time in a very long time. The last 2 years, I think, their filings are down because they are one of the bigger IP offices in the world. Yeah.
So then just real quickly.
Yeah, what time is it?
Yeah, we're at time. So really
we're cutting into bar time now, sorry.
Bar time, but basically copyright protection. I'll just say the core takeaways of copyright protection is more for manufacturers. a defensive, kind of defensive protection is just make sure any content that's used on your websites or content that's used in your marketing materials is generated by your employees, and educating your employees to not go out and use images they have found on the internet, because that creates unbelievable headaches now. There's there's law firms that are set up and all they do is sue companies for the unlicensed use of copyrighted images. Real pain in the neck. So.
Yeah, Joe and I have had recent experience with this. That client of mine where I'm in-house counsel had an issue like this. And I said, how did this happen, guys? I'm in charge of this. How do we have a copyright, a image on our website that we don't have accounted for? It's someone else's image. And it was like a marketing director from 15 years ago, and this image was that just grabbed images willy-nilly and put them on the website, and it was still buried somewhere on the website. And these law firms that scrub for copyrighted material that's being unauthorized, it's incredible, the software, how they find this stuff. And they're aggressive, and you need to spend some money to get rid of them, and it's a pain in the neck. So just make sure your website, any kind of image that you have on your website, that you're paying for or it's yours.
Is there a statutory damage?
Yeah. If it's registered as statutory damages.
And attorney's fees. So
What are the statutory damages?
upwards of, I think it's $250,000 per occurrence, but
Especially if you alter the image too, then it's like bad news, right? Then you're in.
You'd have to settle like for something.
Yeah.
well, and the nastier part though is because if they've registered the copyright before the infringement occurred or within 3 months of the first publication, they are almost automatically entitled to attorney's fees if they sue you. So they don't care. I mean, it's just like they will file. Yeah, I mean, so it's. Yeah, and
you get a call from a contact center, right? Like it's not even an attorney that calls. Like, yeah, they have a bunch of people with headphones going, "Yeah, you owe us this much, right?" And then then we were in a good position with that one because
It was
they
not
didn't
registered.
it wasn't registered, and we didn't alter it. So I told this person, I said, "Tell the attorney you're working for to go pound sand, right? Or this is how much I'm going to give. This is how much we're going to give you. That's it." And then and he goes, "Well, we're going to file suit, Mr. Scherer." And I said, "Okay, file suit." And they didn't. They took the money that we offered, which was considerably less than if it would have been copyright registered, and it would have been bad news.
So we just give a very broad generalization of copyright protection. Just one last takeaway is, like, if your company is heavily reliant on software, or if you're developing custom software, there's a whole lot more we should talk about with respect to copyright protection. But for that, we'll stop.
Yeah.
Time for cocktails.
Yeah.
So
Any questions before we go to happy hour? Anybody? Oh, really good. Thank you.
thank you.
Hey, next slide with our emails. Our contact info is on the slides. If you want to email us, do so. We'll answer all questions. Okay? Thanks, everyone, for coming. Appreciate it.
Thank you.